Reeves Subcommittee and be driving home about 5 p.m.
Yep.
and swing through Chick-fil-A for breakfast.
Happens all the time.
Not unprecedented. And
It's good that you lose a little weight.
and we can't. Well, you've managed. The gentleman's managed that. I've not quite managed that. That's passed me by. But you know what, folks? We're in a climate-controlled environment. We got. I mean, just think about what we have. We can't. I don't try not to complain about the creature comforts. So, with that, I'd like to welcome everybody to the Setzler Subcommittee today. We have a heavy caseload both in this subcommittee and the Reeves Subcommittee following this one. And then there'll be some action in full committee this afternoon, I'm quite sure. We have a number of propositions to take up. I'm going to give Representative Maynor a chance to kind of prep for her two bills. I'm going to take up Representative Gunner's the HB. I'm going to take up which one first. We're going to
555 or 556.
Yeah, I'm making a decision here. We're going to take up 555 first. Representative Gunner, welcome back.
Thank you. Thank you, Mr. Chairman. I appreciate it. I have two separate bills here, but I want to let you know that these bills are tied together.
Okay.
There was an agreement reached between prosecutors and the criminal defense lawyers that brought these two bills about. And House Bill 555 is what I call a bench trial bill. This is where a defendant can ask for a bench trial over the objection of the prosecutor. Currently, the prosecutor has the right to object to that, and that would then send the case to a trial by jury. The other half of this, and I hope you don't mind if I refer to the other because the two are kind of married together.
Okay.
House Bill 556 allows
Whoops.
Yeah, we're there now.
There we go. Okay. Testing.
Should I
Okay.
start over? I'll be a little quicker.
Yeah,
with it.
just kind of reframe it quickly and get into
Okay.
it if you could.
We have two bills that are actually kind of married together by an agreement between prosecutors and defense counsel. 555 is the bench trial bill that allows a defendant to ask for a bench trial over the objection of the prosecutor. House Bill 556 allows prosecutors to accuse cases rather than take them to the grand jury. Now, it's not all cases, it's a limited right. And both of these bills have sunsets on them. And the idea behind this agreement and behind this legislation is to clear out the backlog of cases that have been created by our COVID situation. The emergency orders from the Supreme Court have restricted or halted at various times jury trials and the convening of grand juries. So it's really very difficult right now to move cases through the system, and this is hopefully to make that better.
Okay.
Now,
No. What we're taking up first is, the context is important. We're looking at 555 first.
555.
So to that point, do you have anybody you want to speak? There are some folks that have signed up to speak. Do you have anybody in addition, as part of your testimony, you'd like to have speak with you on this?
The two that need to talk about the agreement are Pete Scandalakis with the prosecutors and Jill Travis with Gactel.
Okay.
And they can tell you the status of that agreement right now. I think I'd rather let them do that than me try to do it.
I'll recognize them at appropriate time as on their own behalf. Chair recognizes Representative LeClarin for a question.
Thank you, Mr. Chairman, and thank you, Representative Gunter, for bringing both of these. I think they both make a lot of sense and are a great compromise position for clearing a really urgent problem for the courts. On 555, and I expect we'll be talking about rights today a little bit and the importance of a jury in the system. So
Sure.
Is it your understanding that the right to a trial by jury is essentially only held by a criminal defendant for due process purposes, and that there is no right per se that adheres to the state to try a prosecution by a jury, at least for constitutional purposes?
I would disagree with that in that prosecutors represent victims of crimes. And for that reason, I think that they have a right to a jury trial as well.
Okay, but I guess in this case, it seems like then you're doing sort of a balancing of interests, that essentially for this emergency situation, that right should yield to some degree to the efficiency interest.
And that was the agreement. But like I said, they need to explain to you what's happened to that agreement since they formed it.
Well, I'm in for an exciting Tuesday, so thank you, Representative, and I look forward to hearing testimony.
All right, thank you.
Okay. Any other questions from members of the committee?
One thing to add is I do have a substitute that would combine these bills into one.
Okay.
Doesn't change any language or anything like
Sure.
that, but like I said, you need to hear from the others
Sure.
to
Yeah.
understand it.
Yeah, I don't see any other questions from members of the committee. So I as a member of the subcommittee, I just have concerns with the idea of can we give broad powers for judicial? I know we had a judicial emergency, and I just I guess I disagree with the premise that we can't find ways to impanel juries. I think there's ways to do that. I know the system's decided to not do that. I don't believe it's impossible to do it. Given speaking as a member of the committee, that's where I stand on it. I do separate this issue of grand jury from the issue of the giving the defense the ability to, over the prosecution, to ask for a bench trial. So I just have a kind of a policy question there, and I know the gentleman talked about it being a due process interest as opposed to a more basic right. I do think if this legislature, and I know we need to tread very carefully when we talk about anything that even marginally begins to undermine this right to jury. And I know sometimes it goes for you, sometimes it goes against you. If you're on either side of if you're the prosecutor or the defense, sometimes the one might look back or even look forward prospectively and say, gosh, I'd really rather have a bench trial in this, which is why our system exists. When there's consensus, we can go there. But I just have some concerns about this, even for a 2-year period. If somebody finds themselves in a circumstance as a victim that's having their interest represented by the prosecution that just happens to be during COVID, just happens to be during this 2-year period, I think we can contextualize, it's COVID, it's remarkable circumstances, yeah, but for this person in their life and their circumstance, it might have had nothing to do with COVID in particular, and their rights as a victim and their rights as, I think it's easy for us to convince ourselves of that here in this room because it's all common. That makes sense. COVID. Let's contextualize this. But in that circumstance for that person, we have to be real careful about it. So those are my concerns about the jury component. I will recognize Vice Chairman Reeves for a question there.
Thank you, Mr. Chairman. And obviously, I know when Representative Gunter, you know these things very well from being the former DA and a former Superior Court judge, and as a former prosecutor and then also as a lawyer who has done criminal defense, I want to put on my prosecutor hat right now and say it is a lot easier to try a bench trial than it is to try a jury trial if you're a prosecutor. It is exponentially easier. Opportunity for error is much less. The consideration, the all of the things that make a jury trial so stinking hard are things that, frankly, you don't deal with for the most part when you have a bench trial. And when I had, in my time as an assistant DA, there were plenty of cases that were mutually agreeable for to be tried as bench trials. But if there was a reason, the two-party consent to this is there for a reason. And the state has the right to a fair trial just as much as the defendant does. And if there are reasons that the state objects to a bench trial, then it's safe to say that they're probably good reasons. And I say that in light of the fact of how hard it is to try a jury trial and to see a case all the way through where you are trying to make sure that reversible error doesn't occur. And part of being a prosecutor is trying to make sure that the case is tried clean on both sides. If, as a defense attorney, you have there's a error. Creating reversible error is part of a strategy. And as a prosecutor, you're trying to make sure that you don't create error and making sure that no one else creates error either. And so, I think in light of that if the state feels like it should not have to try a case to a judge, then I think that that's something that we should leave in place. And I recognize I can't even imagine what the court system is going through right now. And I recognize how difficult it is going to be to navigate through this. But, a few years from now, when we do get through this, what are we going to look back? And when we see, if we've already had this precedent of, creating this exception, then is that a precedent that we could easily, somebody could make an easier argument that, well, this worked so well, this really ought to be something that we ought to consider, at all times. And if that happens, those are the kind of things that happen. But I think we do well today by looking down the road 4 or 5 years, knowing that there will be a time where we get through the backlog that we are not even begun to get through as of today. But, I think that this is there's a real sanctity to me in the concept of a jury trial, and knowing that how deeply that enhances the state's burden. If the state is requesting that, then I think that should be honored. And I say that desperately seeking some kind of solution that can help us with some efficiency to try to get through this. But this is where I feel like this is a line that I'm not comfortable with crossing, and I don't fault anybody for their involvement with this and for the idea, and it's worthy of discussion. But this is just something that I think that we ought to avoid. And so, anyways, Mr. Chairman, that's all I have to say.
Let me respond to that. I think one of the concerns out of the appellate courts is the speedy trial demands that'll be dispositive of a lot of these cases. So,
you're right. And Constitution. Sure, and I think everybody on the committee. Well, if you're not aware, there's two types of speedy trials. There's statutory and there's constitutional. And statutory is where we say you have to, if they file a speedy trial, it has to be tried within a certain period of time. And there's a concern that when we no longer, right now the executive order has kind of hit the pause button on statutory speedy trials. And there is obviously a concern that when we get through this, if the system could potentially be overloaded in a way that, frankly, it would be code red meltdown if everybody that is pending petition for a speedy trial, statutory speedy trial. And I know that there are some considerations, I believe, being in this building right now on that. And then there's also constitutional speedy trial, which doesn't have necessarily the rigid time frames, but just that you have a right. So in both scenarios, you're absolutely right that there are going to be cases that probably aren't going to be heard within the time limits that are permitted by statutory, and then the concept that's not really limited by time but by circumstances of the constitutional speedy trial. So again, that's why I say I'm desperately seeking a solution, and I hate to be against something and not have something to offer in its place. And I try to make a habit around here of not doing that. So I don't know what the right answer is, but I know that this is something that gives me concern.
Understood.
I got a question to the author. And again, I'm a believer that we can create a structure where 12 members of a jury in a felony case can be impaneled, can go through the process. They can be in play if they need to be 6.5 feet apart. I believe that can happen. I believe we do the things that we feel like we have to do. People go to the grocery store. People make all kinds of important things happen. I think that that impaneling juries is part of what we do, even during COVID. I reject the premise. It's an impossibility. Having said that, if you've got with the pot, so setting that aside, if you had a defendant making a motion for a speedy trial, it seems curious to me they're making a motion for a speedy trial, knowing that they then have, if they had the ability today, they could get together with prosecution and they could get a bench trial agreed to by consensus. It seems odd that you'd have somebody, a defendant asking for a speedy trial and insisting on it, and then saying no, but I'm not willing to. I'm not willing to. I guess I'm thinking out loud about ways that the system can kind of push the sides together to both agree. So anyway, I'm concerned that I believe the system can be made in February, March, April of 2021 to allow the jury circumstance to happen. I'm just not quite convinced that we're at a place of impasse. But having said that, I'm going to let some other folks come speak to it.
Mr. Chairman,
Yes, sir.
I agree with you. Jury trials can take place even while all this is going on. The problem is everything you have to go through to put that together
Understand?
slows the system down tremendously. It's already a slow process. Picking a jury. When I was a judge, I did really good if I could get 3 trials in 1 week.
Yeah.
So, it's not impossible to do it, but it has slowed the system down tremendously, and it's going to be hard to recover.
Okay.
Okay.
Well, stay about close. In fact, if you could, you may want to even speak to what some of the other witnesses say. So I'm going to give them a chance. I've got Cheryl Kavanis. Ms. Kavanis, can you hear us outside in the hall? Could you get?
I can grab her.
Yeah, she's coming.
Here she comes. Am I reading Kavounos, Kavanis?
It's good pronunciation for my bad handwriting.
Okay.
It's Cheryl Karunas.
Karunas.
Karunas,
That's an R.
yes.
Karunas. Thank
And
you,
I'm
Cheryl.
with the Judicial Council, Administrative
Yep.
Office of the Courts.
Yep.
Thank you.
Welcome.
And thank you, Representative Gunter, for bringing these bills. Both of these bills, and if you don't mind, I'll just address the 2 bills that are before the committee today, came out of the COVID-19 task force that was created by Chief Justice Melton and is being chaired by Justice LaGrua. And the task force is comprised of members of all classes of the court, as well as the State Bar of Georgia, Prosecuting Attorneys Council, GPDC, GACTL, GTLA, and others. So, and I was trying to listen out in the hall, and I think I caught most of what you were saying, Mr. Chairman, but basically that's what we spent the last several months doing, is trying to figure out ways to address the backlog. And the intent of these proposals is to provide options, right? The Judicial Council supports these bills and is bringing them forth as potential ways to address the backlog. Some of our stakeholders like one bill more than the other. And, to the extent that the Judicial Council is involved, it's that we feel that any idea to help address the backlog is a good one.
Okay.
And just as Representative Gunter said, it's true we go to the grocery store and we do other things. Unfortunately, the courts have to compel people to come to court and serve on a jury. And it's not just the 12 people, it's the number of people that you have to bring to court in order to get the 12 people and the alternatives, which is why we had the alternative locations bill that has been put on House Bill 635 that's going to allow for more room at a third-party location if need be in order to bring those people together at a safe distance, et cetera. So as for the technical aspects of the bills, I'm going to let the lawyers take care of that, but I just wanted to speak to the position of the Judicial Council and the task force and why we brought these bills forth.
Super. Do you have a question? Chair recognizes Vice Chairman Reeves.
Thank you, Mr. Chair. You know, this is really to both of you, but and it really, Representative Gunter, what you said, the pressure and the burden that the state has with the idea of losing cases because of potentially constitutional speedy trials with the Court of Appeals and statutory speedy trials because the clock runs. But I think that within that, though, that burden that exists on prosecutors' offices to try to get those cases handled in that timely fashion, that's a burden that frankly incentivizes them to look at cases that would be best resolved by that if they can resolve by there's just some cases that you just flat out you got to send to a jury. Some of these cases that rock your community and that they just have to be heard by a jury. But I think the very nature of the problem that we're talking about creates an incentive for prosecutors to look at individual cases, say, you know what, I can try this to a judge. This is a case that needs to be tried to a judge. And instead of mandating that, you know, and I'm not saying it's going to work perfectly, but I also know that if you want to assume that a prosecutor is going to, have the position of, well, we're not going to try anything to a judge in a bench trial if I don't have to, well, then they risk, they throw the baby out with the bathwater, right? Because of the constitutional speedy trial issues that are accumulating and that time is growing and growing and growing. And if there are statutory speedy trials demanded, then they know when the clock's ticking and they know what their drop dead date is. And I think it's going to naturally create an incentive to figure out how to resolve these cases in an alternative way other than a jury trial. And to me, while there's not a foolproof way of doing this, I think the potential for that to happen outweighs the harm I see in requiring the state to do that or having them do it above their objection. And so, anyhow, that's all.
So Vice Chairman Reeves, what I'm hearing you say, for those that are listening, if this were a cycle where there's incentives for this to spiral out of control, that might be a concern. In this case, there's overpressure against the prosecution for doing this because the burdens on the prosecution in these cases is a natural limiting factor in the quantity of these. I think that's your issue. So I think that's meaningful. Chair recognizes Representative McLaurin.
Thanks, Mr. Chair, and thanks for coming today. To this point about the state's objection and the availability of a jury notwithstanding the waiver and the objection, well, I guess it wouldn't be notwithstanding the objection. I see on lines 23, 24, even if the defendant has waived a jury trial, the court may nevertheless order a trial with a jury. I guess my question is the intention there to allow the court to hear the prosecutor's objection and make a judgment on a case-by-case basis about whether maybe a case does fall into this category of essential that the community hear it via jury and participate in the disposition of the case more directly?
I think that's correct.
Yes, I don't think it's spelled out there, Representative McLaurin, but I do believe that that's the intention, and it certainly wouldn't preclude that from happening.
Okay, thanks. I think that, in my view, that does tend to address what you might call the safety valve issue here, which is that while this might be an appropriate remedy during the emergency in the main, there might be some absolute exceptions where we insist that a case go before a jury and the court could hear the state out on that. So I appreciate you including that provision. Thank you.
Thank you.
Any further questions from members of the committee? Seeing none, thanks for being with us.
Thank you.
Thank you. Appreciate you being here. Chair's going to ask for Mr. Pete Skandalakis from Prosecuting Attorney's Council.
2 Greek names in a row.
I tell you what, it's. Of course, I do see the red light going, so I'd like to say, hey, everybody, I'd like to welcome the public to the Setzler Subcommittee. Mr. Skandalakis, welcome.
Thank you, Mr. Chairman.
No stranger to the subcommittee.
Always a pleasure to be here in front of some of my favorite people. Sometimes yeah. I said some. I'm trying to be honest. I'm here on behalf of the Prosecuting Attorney's Council, and I think you just heard from Ms. Karounis, who also is Greek, by the way, so you have 2
Indeed.
Greeks back to back. Prosecuting Attorney's Council was one of the stakeholders that was at the table. And there's some things we liked. For example, I think it's 556 is the accusation bill that allow us to bypass grand jury on certain offenses, not all offenses. The 7 deadlies would be excluded. And certain things that Prosecuting Attorney's Council objected to, which is this bench trial bill, without the consent of the prosecutor. Now, there's either an understanding or a misunderstanding between the PAC and GACTL that that we would both agree to, stand down on the accusation bill on behalf of GACTL, the bench trial bill on behalf of the Prosecuting Attorney's Council. I say that's a misunderstanding because the DAs have a representative here. I think you'll be hearing from Tasha Mosley next. And the DAs will let you know that they object to 555, and unless the 7 deadly sins are added to that. And so I will let the DA's representative speak to that. But I just want to make that point clear because I don't want there to be some misinterpretation about what role PAC played when the Judicial Council came up with these proposed rules to move the cases.
Any questions for Mr. Skandalakis? I've got a question. I am clear as mud. I'm sorry. So does, and I know PAC tries to step back from leaning on policy things. Is there a concern about, for example, some concerns were raised by Vice Chair Reeves about this. Would PAC broadly have concerns, or is PAC just not going to touch that?
You know, what I would tell you is that when we were at the table with the Judicial Council, the COVID task force, we objected to the bench trial bill.
Okay.
Defense bar objected to the accusation bill. So both were placed on there as kind of a consensus with, a misunderstanding or an understanding that PAC would stand down and the DAs would stand down and GACTL would stand down on each other's bills. When I sent these 2 bills to the DAs Association, the DAs were adamantly opposed to 555. Okay. And so that's why Ms. Mosley's here. She's an officer with the DAs Association to speak to that issue. Did I clear that up at all?
It sounds like a stalemate in the Middle East, that both sides don't have something they want, therefore there's consensus.
I think that's I think you hit the nail on the head.
Okay, appreciate that. Chair recognizes Representative McLaurin for a question.
Thanks, Mr. Chair. To Vice Chair Reeves' point about prosecutorial decision-making and choosing whether to object, and Vice Chair Reeves opined that it would be probably for good reasons across the board if prosecution did object. This is maybe my own ignorance, but I guess I would like some clarification on why a jury trial would be necessary over and above what a bench trial could provide in the prosecution's view, apart from a more abstract philosophical notion about the community's involvement in the case. Because I guess, if I put on my totally biased defense hat for just a second, what it kind of sounds like, just a second, right? What it kind of sounds like is that we want to ride the motorbike real hard on Rule 403 and we're not going to violate Rule 403. We're not talking about undue prejudice, but what we're talking about is the jury emotionally understanding the case or something like that. That, you know, a judge is I think we would agree a judge would be more dispassionate and removed from the emotion of a case in general. And so I'm curious what, apart from trying to access emotion of the jury or this philosophical justification for a jury trial, are prosecutors really interested in if they object?
Yeah, I think I can answer that. The judges are human beings, and judges have, as much as they, many of them are unbiased, there are some judges that that aren't unbiased. I mean, there's no other way to say it, but some judges are more inclined to lean one way than the other. And I think the prosecutors would prefer to have that case in front of a jury. Some cases, not all cases. Some, you know, they might consent to some cases. I don't know. It's been a long time since I've been, it hasn't been a long time, 3 years since I was a prosecutor in a courtroom. And again, I would have no trouble trying my cases in front of a bench trial.
Okay. And I don't mean to be a pain about this. I just think, and to the chair's point that you've made on other bills, it's good to know why we're making the arguments we are. And I think it's, you know, that's some strong medicine to say that we need an insurance policy against biased judges. And if that is actually the position on this, you know, I think that's just good to have in mind. I haven't really given a whole lot of thought to whether I'd vote one way or the other about it, but that's different than saying that there's some sort of neutral or dispassionate structural reason why we want prosecutors to be able to object.
I think there's a multitude of reasons, and one of them is what I said. I mean, there are some judges that lean, you know, one way, some judges lean another. And that's my honest opinion.
Thank you.
And to the gentleman's question, I mean, I appreciate you directing it at the chair. I would say I might note that abstract and philosophical is not equal to less than, right? It's not the same. And I do think, you know, we debate first principles, that they're helpful to us. I think if we were contemplating a circumstance where one side could get one bench treatment versus jury treatment, and we're going to effectively eliminate one for one side of the equation between the judge, between the prosecution and the defense. If we were going to eliminate one and we had to choose, I would eliminate a bench trial, because I believe that a jury trial is a foundation. It is a abstract and philosophical hallmark of our system, and so I think I think we do it with caution. And I think it's you think about what we do here, it can grow in ways that sometimes we don't foresee. In my even in my short time down here, Chair recognizes Representative Reeves.
Just real briefly to Representative McLaurin, you know, I think that with judges, complex civil cases are very different. They usually don't have a lot of they're unique cases. And I think that when a judge hears a complex civil litigation, it forces, you know, a closer consideration of things, because they're not as they're not as consistent. Really, a lot of criminal cases and a lot of domestic cases, it's kind of the same thing over and over and over again. And, you know, frankly, it doesn't take long before the lawyers kind of have an idea of this is what this judge is going to do in this particular fact pattern. And if you're the assigned prosecutor to a courtroom, it doesn't take you long before you realize this judge has X amount of appreciation for these type of criminal cases. And maybe part of that is the duty and the right of the judge, but on the other hand, the state has an obligation to present its case that it's ethically bound to do, and ought to be able to do that without any bias on behalf of the umpire. And, you know, and I think that it's just that it's criminal law. It can get very, very repetitive. You see the same things over and over and over again. They're different people. You see the same things. And so you really kind of get a sense of where a judge may be. And I think that that's kind of what causes a lot of what we're talking about.
Chair recognizes Representative McLaurin.
Thanks, Mr. Chair. Very briefly, I think, you know, today our opinions and perspectives seem kind of set. I'm more or less just want a video record for for later discussions when we talk about judging, because I think this is an important point, that we do bring perspectives into this committee about how judges tend to act that are specific to individual personalities. And I think that's important for us to remember as we continue to do work at the committee.
Well, I will look at the camera, Representative McClure, and I will say, I am committed to the jury process. And I can say that I'm committed to the jury. I'll say it any number of times the gentleman would ask. So I'm out of the closet on that question. I'm quite very much there. So with that, Mr. Scandalakis, thank you for being with us. Appreciate your time. I'd like to recognize Ms. Tasha Mosley. Representative Byrd, did you have a question for Mr. Scandalakis?
No, I didn't. Just
Okay.
kind of just general.
Chair recognizes Representative Byrd.
So I'm trying to understand this, listening to the entire discussion here. Are we trying to eliminate jury trials for serious crimes and go to what y'all are now discussing, a bench jury or whatever that means?
Ms.
So
Trump, sure.
going from a jury, an actual jury where you choose people to hear the case as opposed to whatever a bench is. I'm not quite clear about what the bench means, please.
To that, I'm going to recognize Representative Gunter to explain the contours of the bill, exactly how it works.
The way they have it set up is that the defendant can ask for a bench trial, and it could be in a serious case.
Please.
A bench trial is before the judge. There's no jury involved.
No jury involved.
The judge becomes the fact finder in the case, as well as the one that applies the law to the case.
So a bench trial is strictly with the judge and not with a jury?
Correct.
Thank you.
And typically, well, the typical circumstance when you have agreement, could you walk her through the whole, how that plays out?
You mean like for a plea?
If you're in a circumstance of both defense and prosecution agree.
Oh, if they agree, then, that happens currently. If they're in agreement, then they go to a bench trial.
Right now, if both sides agree, it's a bench trial. If either side objects, you have a right to be before jury. And that this would change that the defense can, in essence, make the case we want to be before a judge and not a jury. And the prosecution could never come that. That's the proposition.
Thank you very much.
Sure, okay.
Ms. Mosley, introduce
Much
yourself.
more clear now.
Welcome.
Oh, welcome. Thank you. Thank you. You guys know I only come up here once a year.
With
You
the-
should come more. You should be up here a lot more.
If I'm not mis-
I try to avoid it when you're.
If I'm not mistaken, you have a pretty good batting average in this committee, though.
Well, I hope we keep it going. I'm Tasha Mosley. I'm district attorney in Clayton County, and I'm also secretary of the District Attorneys Association. And I'm here to speak on behalf of this bill. We just have a couple problems with it. And our main problem is the fact that, one, the 7 deadlies could actually, it's not written out of this. You guys have not put it in the accusation bill. You found that it still should go to indictment, but it's not specifically written out of this bench trial bill. And that's very concerning. If you think that we need to still get an indictment, which means it needs to go to the grand jury, and at least 12 people vote for an indictment, why not keep that on a jury trial instead of bringing it before judges? And that goes then to our victims. We have victims who want to be heard by their peers, by the citizens. 12 sitting in that box with a couple of alternates to hear the exact facts of the case. And not a judge. And we're taking away that right. We went through all of this with the Victims' Bill of Rights and making it a constitutional right, and we're taking it away with a failed swoop of a pen. COVID has been a beast. There is no lie. It has been a beast on the judicial system. And we all have backlogs. There are parts of my office right now I refuse to walk by because I have anxiety attacks. Looking at the cases that have to go before a grand jury, knowing what's going to happen once we do open up. Because defense, let's be honest, defense is going to use speedy trial demands as a tactic. And I've got to get those SB 440s. The other 180s, I've got to get all of that done within the time frame, then look at jury trials and possible bench trials of crimes that I've got to put in front of a judge that I would normally not put, that are real serious crimes. That's a problem. I'm a little scared for my victims, and I'm scared for my community. And let's talk about the deviations. Now, we all know how hard you guys work to put in mandatory minimums on certain sentences. And right now, there has to be an agreement with us and the judge saying, okay, we'll basically lower it down to something lower so that you don't have to stick with those mandatories. But what if you, with this bill right now, with this bench trials, they can get past the mandatory minimums by finding a lesser included. And there is absolutely nothing that I can do or any of my colleagues could do after that. If he finds them guilty of a lesser included, we're precluded. So it's a complete bypass of what you were looking at, with your mandatory minimum sentences. I know we have a problem. We all know we have a problem. But I'm not exactly sure that this is the way to fix it. That's basically where we stand.
Thank you, Ms. Mosley. Great testimony. Chair recognizes Representative McLaurin for a question.
Thanks, Mr. Chair. Thanks for testifying. If we were to exclude 7 deadlies from the bench trial bill, would that move you personally closer to feeling like 555, 556 were an acceptable compromise package for dealing with the crisis?
Yes.
Thank you.
And I think most of the DAs would feel, because that was the first thing out of everybody's mouth was like, the 7 deadly haven't been excluded.
And Mr. Chair, for the record, I think, I would be fully in support of that change if that is something that would bring the committee closer, because you speak with judges about this, and obviously you share the same concerns. It may be apples and oranges in terms of philosophy or community involvement or however you want to describe it, but it is a really felt crisis. And I think people are really, like you say, anxiety. I think people are really sweating bullets over this. And the fact that you have this task force with these efforts at compromise, regardless of whether they break down or not, I mean, it's a rare thing for me to get in efficiency mode when it comes to the criminal legal system, but that's the mode that I personally am in addressing these measures. And so if moving away from 7 deadlies on bench trial is something that would work for people, I think it's something the committee should really consider.
Chair recognizes Representative Reeves.
Thank you, Mr. Chair. Thank you, DA Mosley, for being here. Always great to have your testimony. You obviously had you were out in the hall, so you heard some of my commentary earlier on what I would consider to be the built-in incentive that prosecutors would have to figure out ways to make agreements on cases that could be best tried before a judge. What are your, I believe that this kind of builds with the burdens that hang over you with all of the deadlines that you have, and then the more gray constitutional speedy trial issue you'll face at the Court of Appeals. Do you agree with me on kind of that built-in incentive? And do you think that, you're obviously in the DA's Association, an officer. Am I off base, or do you think that prosecutors are going to be as creative and more flexible than normal as possible to try to figure out ways to alleviate the crisis that we have?
Oh, yes, sir. For me personally, I'm taking a hard look at cases that my prosecutors bring before me. For example, I had a case that the female, her oven broke in the apartment complex, and her neighbor was moving out. And so she went to her neighbor, the next door neighbor, took that oven, which was good, and we're talking during the holiday time, put it in the apartment and put the bad oven in the apartment, and the apartment complex had her charged with burglary. And I'm sitting there looking, the property never left. It would just move from like apartment A to apartment B because it was Thanksgiving time and she wanted to cook for her family, and the apartment complex had told her it would take 3 weeks for them to get her a working oven. And I'm sitting here going, seriously? She was arrested? No, this is not something that I'm going to try for burglary, because the apartment complex still had its property, the property that was working and the property that wasn't working. It just moved from one place to the other. They were not hurt. I'm looking at cases right now, and that's just one of them that I remember.
Thank you for that decision, by the way.
Thanks. But those are the type of cases I'm looking, and I'm saying, where has the public been hurt? If the public has not been hurt, if my citizens have not been hurt, if Walmart has got their 55-inch screen TV back, and this is a person's first time, buy, go. Do not come and commit a crime again here in Clayton County, preferably nowhere in the state of Georgia, but definitely not Clayton County. I'm letting them go because I'm looking at that backlog of cases, and I'm only trying to focus on those where you have harmed my citizens. My murders, my rapes, my ag assaults. Those are my primary, my SB 440 juveniles. Those are my focus. Right now, honestly, if it's not that egregious, yeah.
So even without this mandatory bench trial at the discretion of the defense, even without that being in law, is it safe to say that your office, that your assistant DAs will potentially utilize the concept of a bench trial more so than they may normally, just in light of all this? I mean, is that kind of a directive that you see DAs across the state looking at?
Yes, to try to clear up the backlog, most definitely. On those little itty bitty things that we can, yes.
Thank you, Mr. Chairman. Vice Chair. D.A. Mosley, thank you for being with us.
Thank you. Always a
time.
pleasure.
Yes, indeed. Thank you. Chair recognizes Miss Jill Travis from Gactyl to speak to the committee. Ms. Travis, welcome.
Thank you. Armful of stuff today.
And the last time Representative Byrd was in this committee, I think you were sitting at that end of the table
there.
down there in a different role.
Yeah. Playing a different role today. Good afternoon, members of the committee. I'm Jill Travis. I'm the executive director of the Georgia Association of Criminal Defense Lawyers. I've been trying to listen outside. It's hard in the hallway because there's a lot of distractions, and we've had some microphone issues, but I've been trying to keep up.
I'm told my voice is very soft and meek and often not. So for that.
They don't know you in real life. So just to give a little historical perspective to add on to what's been going on here, is this has been a very long process to get to the point to where we are today, which was House Bill 555. The COVID task force met for weeks and weeks, and all the players in that, Cheryl was able to explain to you the various members of that task force, and you could tell that it was an even field, but probably the biggest set of players on that task force were judges. And the bottom line is, for a bench trial, do you trust a judge? Do you trust a judge to make a decision? Right now, the only way that a judge can hear a case, a bench trial case, is if both sides consent. Contrary to Representative Reeves' characterization of this bill as being a mandatory bench trials, there is no mandatory bench trial. This is only that the defense can ask for it, the prosecution can object, and then the judge can decide whether or not she wants to hear the case. And I don't know that there will be an avalanche of bench trials, but I think that the district attorney that just testified gave a good example. There are circumstances where a bench trial can move the case, can move a docket. There are cases where there are pretrial motions that have been decided in a certain circumstance, and we know that once the Court of Appeals hears the case, that's going to be the finality of it. And so having the time with a bench trial is not really worth the time and effort. When we went through the process with the task force, these issues came up. The DAs or the prosecuting attorneys were asking for the ability to have an accusation rather than an indictment for a period of time. Well, first it started indefinitely, and then it was for a period of time, because this is supposed to be a reaction to the pandemic. And similarly, the defense lawyers were asking for a period of time. Can we have a bench trial without the consent of the prosecuting attorneys? Not that they couldn't object. And seriously, I don't know. I mean, Representative Gunter is probably in the best role here with all the hats he's played, of saying, if he was sitting on the bench and he had a prosecutor jumping up and down about why this should be tried before a jury, I can't imagine that the judge would just say, well, bully on you, man. I'm just going to try this case with a bench trial because my friend over here, the defense lawyer, is convinced me otherwise. I mean, this is a system. This is a system. There is no constitutional right for a victim to have a jury trial. The only constitutional right involved here is the defendant's right. And we had agreed to stand down on the accusations, and they had agreed to stand down on the bench trials because we all agreed that it was better for the system. We have talked to, so in vetting these bills, there's not a single judge that we have spoken to that didn't think that having bench trials was a good idea for a short period of time to see how it works. And then if the sky falls, there is a sunset in this. It's not a forever thing. And the same with the accusations is it could be brought, it could be lifted as the time period expires. I think we're just, because I missed the beginning of the hearing, I think we're just supposed to be testifying on 555.
We are. I mean, I don't mind kind of moving into 556 if it's relevant in context. I've got a question for Ms. Travis. Are there any questions from members of the subcommittee? My question is, typically, it's not always the case. Typically, defendants are not urging to get. It's often the case that the defendants, the longer things drag out, that's not against their interests. The idea of speedy trial, those rights do exist, but it's oftentimes the case that things being drug out is not against the interest of the defendant, and particularly from the perspective of their counsel. So the idea of there being some delay is not always going to be something that's not welcome to the defense. It seems that because of that, and because the defense seems to be so in support of this concept, the idea of moving things through the process seems to be a judicial interest and seems to be a prosecutorial interest. Doesn't seem to be the defense interest, although there's this notion of a right to speedy trial. So that being the case, it seems to me that for defense to be so committed to this, there seems to be a real difference in the potential outcome that could come as a result of this, as opposed to balls and strikes by a jury. If it's balls and strikes by a judge, balls and strikes by a jury, it seems that the committed interest of the defense generally in this concept, the only thing left is to conclude that the interest is there's a different outcome in cases than there would be if it was tried before a jury. So I hear that and I think about that. That doesn't build confidence that the interest is simply to move cases. That's my concern.
Well, I'm here to tell you you're wrong.
Okay.
I mean, it is to move cases, and very often, it's the innocent defendant. Now, the case in which the state has a great deal of evidence against the defendant, and there's serious charges against the defendant, I would agree with you that time is usually the defendant's friend. But especially the people that are saying, hey, I'm not guilty. I just want a trial. I just want to get out of it. And sometimes people just want trials because they just want to have it heard by somebody and to move forward, even if they know that the end result is going to be a conviction, that they just keep moving through the system. So, I mean, it was clear to the judges and the committee that heard, and in terms of the task force, what you've got is you've got a subcommittee of criminal law, the criminal law subcommittee, and then the full judicial task force. And then this bill went to the legislative committee of the Judicial Council, and then it went to the full council of the Judicial Council. So it's been through 4 layers with a ton of judges who have looked at this and have said, this makes sense to resolve issues during the pandemic.
Isn't it fair to say that the judges would probably be kinder to their own judgment in the context of, as an association, a group of 100 judges would say, we make better decisions than juries do generally. It wouldn't surprise me if 100 Superior Court judges in a room ask, do bench trials represent justice more consistently and without error more frequently than jury trials? I think the judges would overwhelmingly say, perhaps not on camera, but in an anonymous vote would say overwhelmingly yes. So it doesn't surprise me that a judicial body would say, yeah, they're going to be better at this than a jury. That doesn't surprise me. So a judicial entity proposing this, I can understand why they might think that, but I don't know that serves the justice interest we're called to weigh. I mean,
as a former judge, I would disagree with that. A lot of very serious cases come to trial because the cases are not real clear. And I think 12 people in a box in those kind of cases can make a better decision. And I think in most cases that go to trial, I would prefer to have a jury hear it than for me to hear it as a judge.
Yeah,
And especially in serious cases. I don't want to hear the fact finder in a serious case. I'd rather have a jury in a serious case listening to the evidence and deciding it.
particularly a very prominent case that might lead to an acquittal that might not be a popular acquittal.
But even the cases that aren't so prominent in the public's eye, there's a lot of cases that are very serious. I'm talking child molestation,
Yeah.
things like that, that I would much rather have a jury decide.
Sure.
So.
Do you recognize Representative McLaurin for a question?
Thanks, Mr. Chair, and I will style this as a question. Ms. Travis, did you hear? You heard when Vice Chair Reeves was talking about the opportunities for error in a jury trial. Were you present for that part of the hearing? If not, I can remind. So I mean, some of the things he mentioned were possibilities for error, reversible error, potentially at the appellate level, if instructions are given to a jury that are if argument is given to a jury that's incorrect based on the legal instructions, or if there's inflammatory or prejudicial argument made, if there are errors in the jury selection that could have to do with race or other infirmities. So, I mean, you would agree that when a judge says there are fewer opportunities for error in a bench trial, it's not simply an assessment of the judge's own competence, right? I mean, it also has to do with structural reasons why there's more threats to efficiency and finality when a jury is introduced. Would you agree with that?
I would agree with that.
Okay.
Yes.
I just wanted to make sure the chair was aware of that angle of the discussion as well. Thank you.
Do you recognize Representative Reeves?
Yep. And what I was talking about earlier, kind of in a broader context, was it's a lot harder for the state to try a jury trial than a bench trial. There's a lot more work that goes into it. There's a lot more potential for error. There's and in my opinion, it's a lot easier to try a bench trial. And I think that what I've tried to get at in some cases today is that if the state is seeking a jury trial on something as opposed to a bench trial, then it's a harder road to hoe, and so there's probably a reason why, and then I think that we should honor that reason. And I do want to say, you stated, and I stand corrected. In fact, Judge Gosselin texted me and let me know that the bill doesn't require that it be a bench trial, that the judge can say, I understand, but the jury's going to hear this. And so I do stand corrected I misspoke on that earlier.
Ms. Travis, anything else?
Nothing further other than we're just trying to make the cases move more efficiently. And it really is an option. I don't know that defendants are going to be pouring through the doorways to scream and demand bench trials, and but this is just one small door opening that can help for the efficiency, and I think that's how all of the folks that have seen it so far, and to the extent that the bill does provide protections that when the defendant is doing this, he's doing that knowingly, and the judge is confident of that, and then that the judge. We have confidence in the judge to make the ultimate decision of whether she should hear the case or not. And we would ask for your favorable consideration of it.
Go ahead.
Representative Reeves.
I'll waive.
Ms. Travis, thank you for being with us. Appreciate always appreciate your insight. That's all the speakers that decided to speak on the bill. To the author, any last remarks on 555 specifically for the committee?
Yeah, let me just say there haven't been any judges here to defend themselves, so haven't been there before. Let me just say that, like a lot of businesses, this is a people business, and that includes the judges. They come from a lot of different backgrounds, a lot of different type practices. Some are more comfortable with criminal law than others. I was very comfortable with it. I was like a fish out of water when I did civil cases. And judges have their own biases. We all do. Everybody does. And those that appear in front of a judge regularly get to know them better. And so they kind of know how they're going to react to a certain situation. So they're not bad judges. This is just what we have. They're good people trying to do the right thing, and you may not agree with it. That's what appellate courts are for. I also want to say to those that have been watching this, don't get the idea that you can commit some crimes because of what you've heard here today, that prosecutors aren't going to be prosecuting certain types of crimes. You're gambling a lot if you want to get out there and try and commit a crime and think it's going to be waved away by the prosecutor. Because we're doing this in public, and that
Sure.
I want to make sure everybody understands that. You're rolling the dice.
Okay. Any discussion from members of the committee for the author? Chair recognizes Representative Byrd.
It's more of a comment than anything else. Of course, COVID has been a burden on everyone since last March. I mean, whether it's jury cases, bench cases, whatever it is. But I do know that the difficult part around this capital and the decisions that we make, that once you open a door, it doesn't seem to ever close. Thank you.
Chair recognizes Representative McLaurin.
Thanks, Mr. Chair. I actually feel that this is a really sensible bipartisan solution with a door that closes on line 28. There's a sunset date. I mean, we have recognition that this is a short-term solution where we're weighing apples and oranges against each other to try to get the best outcomes and make sure the system doesn't fall apart, frankly, in some more cataclysmic way where we get outcomes in these cases that are very divergent from the interests of victims and the community. I mean, I think that's really what this is about. I'm in a posture where I would be prepared to go ahead and propose an amendment on a motion to exclude the 7 deadlies from this bill and to bring it in line with 556. If we reject a bill like this that is a product of months of work, that is meant to address a historic crisis, and one of our reasons, or our main reason for doing so, is bias in judging, I don't think that bodes well for the work of the committee moving forward. I think it means that, to me, it would suggest that we're going to have somewhat of an arbitrary view about when we do or don't trust judges according to when the policy lines up with what we do or don't want. And I don't mean to make that accusation towards anybody in particular. I just mean I think we run the risk, if we don't trust judges to some extent on the management of what former judge and now Representative Gunter explains is a people's business, where the people involved who are most closest to it have an idea of how to manage it. I mean, this is an administrative bill in many respects, but it does require a slight compromise in a statutory right for a temporary period of time to affect it. If we don't afford that trust, then I think we lose a little bit of credibility. So that's my view on that, but I think it's a really strong effort by a lot of very capable minds who are close to the system, and I'm in full support of both of these bills. Thank you.
Chair recognizes Representative Reeves, Vice Chairman.
And as just discussion, and I can certainly see both sides of this, and I also am much more comfortable with the idea if we did pull out 7 deadlies. However, I think that there are frankly a lot of other offenses that, such as trafficking, human trafficking, aggravated assault with a firearm, aggravated battery with a firearm, that I consider to be, aggravated battery, it means that you got shot. Armed robbery is a 7 deadly. That means that somebody produced a weapon and robbed you. Aggravated battery is arguably more serious than armed robbery. I think that I'm more comfortable with the idea of pulling out some of those offenses, but I feel strongly my gut tells me that there is already a built-in incentive for people to take advantage of whatever options are out there, and I would rather trust or give deference to that incentive is going to work than to make a change in law that, when this sunset is over and things are back to quote normal, that that we now have a new policy that we're arguing to extend for different reasons than we're arguing for it now. And so I really, really think that the burdens that the state has is going to incentivize them to be very creative on a lot of different levels, not just bench trials. And so, it's for those reasons, I think I've come to the place where I understand and I appreciate the work that went into this, and I appreciate the different perspectives, but I think that we have the ability to work through these issues without mandating something like this right now. So.
Thank you. Before the chair recognizes members to make a motion, any last word from the author?
I'll leave it at that. Thank you.
Thank you. Okay, what's the pleasure of the committee?
I'll move to pass. Second.
Got a motion do pass and a second. I've got a motion do pass and second. Are there any amendments?
I'll move an amendment. Let's see, I want to make sure I'm doing the right place. I would put a new subsection E after line 28. This code section shall not apply to the prosecution of a serious violent felony as provided for under code section 1710 6.1.
So your amendment is not limited to 7 deadlies. It's serious violent felony, or is that the 7 deadlies chapter?
I believe that's am I wrong that that's the?
I think,
Yeah, we'd have to look.
I
I
think
think
it's-
that's the 7 deadly definition. Am I wrong?
I think that may be
I'm
broader
gonna
than
laugh
7
if I'm
deadlies.
wrong.
1710 6.1 is 7 deadlies, isn't it?
That's what I thought it was. Yeah.
Can you grab Title 17 right there on the second shelf in the middle?
Yeah, and subsection A defines serious violent felony to mean 1 through 7. So that is the amendment, yeah. Oh, okay. Sorry about that. I'd like to add a new subsection E. Or actually, since I get a mulligan on this, why don't we do a new subsection D that starts at 28, and we'll renumber the current DE, just to make sure the repeal is at the end. And the new subsection D would say, this code section shall not apply to the prosecution of a serious violent felony as provided for under code section 1710 6.1. And that's the amendment.
Are there any questions on the amendment? Okay, and do we have a second on the amendment? Is there a second on the amendment? The McLaurin amendment. Is there a second? Hearing none, the amendment fails for lack of a second. We do have an underlying do pass motion on the underlying bill. Is there any further amendments to be offered? Any further amendments? Hearing none, any further discussion on the bill? We have a do pass. So we have a do pass motion on HP 555, LC 412945 with no amendments, as authored by the author of the bill, Hearing no further discussion, all those in favor of it sending it forward signify by raising your right hand. All those opposed? It fails. That's HB 555. Representative Gunter, appreciate your time and deliberation. I know we've talked about 556. 556 is if it pleases the author, I'd like to take that up. I know there's been some discussion around that. So I'll turn your mic on and let's address 556.
All right. This is the trial by accusation. I believe it does eliminate the 7 deadlies as being one that a DA could try by accusation. And it basically sets out the parameters in which they would operate by accusation. We already do a lot of drug cases by accusation, but it has added to that on line 40 and 41. And basically, it's the kind of crimes where probable cause has already been found in another court, which is what the grand jury does anyway. And so that's the reasoning behind the changes that we have here.
Any questions from members of the committee of the author? I've got, I have no entities. No, I do have a couple signed up to speak on this. If you're listening in the hallway, if Ms. Koronis, Skandalakis, and Mosley, if you guys want to come, I think we can maintain separation at the back of the committee room. Why don't you guys come on back in and I'll recognize you guys to speak to 556 specifically, since we didn't spend much time on that earlier. I'm going to recognize Ms. Koronis has moved on. Mr. Skandalakis, if you want to come on forward for us. D.A. Mosley, thanks for being with us. Here we go. Yep. Yeah. Oh, yeah. Ms. Travis is always welcome. So let's. This is what I would call spontaneous organization. We found a place for ourselves. It's great. We'll talk from our respective places. Ms. Koronis, if you could, could you push your button there or tell me what your number is?
Number 15.
15. Okay. You are recognized to speak on 556.
Yes, sir, Mr. Chairman. Much like my comments in the beginning, we talked about 555. This is another bill that the Judicial Council supports that came out of the COVID-19 task force. This bill pretty much provides for all felony cases because currently they have to be presented to a grand jury, but it would allow the district attorney to file an accusation for felonies not included in the 7 deadlies. So that way, that's why we're kind of calling it shorthand, accusations versus indictment, instead of getting an indictment from a grand jury that
Sure.
you could proceed through accusation.
Okay. Any questions for Ms. Koronis? Chair recognizes Representative McLaurin for a question.
Thanks for testifying to both bills. I would assume that the committee's rejection of House Bill 555 does not change your position on House Bill 556. Would that be fair to say?
They're standalone bills, Representative. I mean, I understand the justification for both bills, but the Judicial Council supports both ideas.
So even if my heart is broken about HB 555, you would still like a yes vote on 556. Is that correct?
We would have preferred a yes vote on both. Yes, Representative.
I would have preferred that too. Thank you.
Any further questions, Ms. Koronis? Thanks for being with us.
Thank you.
And you're welcome to stand by if you want to
Okay.
stick with us in here. Chair recognizes Mr. Skandalakis. What's your mic number there? Is it 3? Chair recognizes Attorney Skandalakis.
And Mr. Chairman, I don't think there's anything I can add to anything that Ms. Mosley will say, so I would defer my comments to Ms. Mosley at this point.
Okay, Ms. Mosley, what's your mic number there? 10. Ms. Mosley, welcome back.
Thank you.
You're recognized to speak on HB 556.
We are not opposed to 556. We like the ability to be able to draw those accusations by passing the grand jury on those charges.
Any questions for Attorney Mosley? Chair recognizes Representative McLaurin.
Thank you, Mr. Chair. Thank you again. We just heard an extensive ode to the creativity and ability of prosecutors to manage this moment with deftness. I have no doubt in your ability to do so. But this bill would add an additional tool for you to be creative with to manage the crunch of the pandemic. Do you feel that this tool is necessary in addition to the creativity and tools you already have to solve the crunch?
Yes, sir, because during this period of time, we've been trying to get defendants to waive indictment on these charges, and they will not do it. They just want to sit out there and try to wait us out in hoping that, the statute of limitations or a speedy trial demand. So we have attempted, talking to them, negotiating, saying, can we just do, waive your right to grand jury, do this on accusation, and let's go. Because a lot of defense attorneys have told us we have reached agreements. We have reached plea agreements. But because we can't do an indictment and their defendant doesn't want to come in right now, if we can have the ability to do an accusation and get them before a judge, and a lot of these are pleas. It's the funny thing. Right now, they're enjoying their freedom in the COVID-19 era right now because we can't do an accusation, and they know it. It has to be done by indictment, but we have an agreement. It's a catch-22.
I understand it would add more flexibility.
Yes.
Thank you for your testimony.
Chair recognizes Attorney Skandalakis.
Mr. Chairman, I made some background to this. In December, we were asked to do a survey of how many district attorneys, how many undrawn cases were sitting in a district attorney's office as of December, end of December. Of the 49 DA's offices, we had about 41 or 42 respond. And by an undrawn case, what I termed an undrawn case was a case that had been filed with the DA's office, but an accusation had not been prepared yet, or the case had not been reviewed for pretrial diversion, dismissed, or an indictment was required. The number we got back was about 60,000 pending cases at the end of December. Now, all those cases don't need to go to grand jury. Some can be charged by indictment, some can be pretrial diversion, some can be accusations. But that's the number of cases that we were looking at, undrawn cases inside a DA's office at the end of December.
Thank you. Any questions for Attorney Skandalakis? Hearing none, thanks for being with us.
Thank you.
Ms. Travis, what's your mic number?
It's
Number 11. Chair recognizes Ms. Travis.
Thank you, Mr. Chairman. I just wanted to say for the record, I'm a person of my word. My organization is a person of their word. We're not going to fight about this. And we would ask you to pass House Bill 556.
Okay. Any questions for Ms. Travis? Seeing none. To the author, any further, anything further to present to the committee before we consider
Just as my experience as a prosecutor, much easier to bring accusations because I don't have to wait for a grand jury to come in and convene and then make the presentation. If we're trying to move cases faster, this would do it. So that would be my comment.
Any further questions for the author? Seeing none, what's the pleasure of the committee on House Bill 556?
Move to pass. Second.
I have a move to pass and a bipartisan second. Thank you for that. We're looking at LC version 412944 from Representative Gunner. Any further discussion on the bill? Chair recognizes Representative LaClarne.
Thank you, Mr. Chair. Today we consider two bills, both bills involving statutory rights that stood in the way of more expedient disposition of criminal cases. In 555, the statutory right was for the state to consent to a bench trial. In 556, the statutory right is to require an indictment rather than accusation with respect to certain offenses. In 555, the interest was the state's interest in a jury trial. In 556, the interest was, as the DA put it, enjoying freedom. God forbid that somebody enjoys freedom granted them by a statutory right under the laws of the state of Georgia. There is no material difference, in my view, in the right that we chose to get rid of versus the right that we are going to maintain. The only difference really is in the policy priorities of the committee with respect to which values to protect and which values to dispense with because of COVID. You could take almost every argument about how COVID is not quite as urgent as we think and we can make our system work and prosecutors have all the tools and resources available to them that they need to get through this crisis, and you could airdrop them from 555 into 556 and it would lead to meaningful debate. But that's not what happened today. I share Ms. Travis's frustration. I'm not here to play games, so I'm voting yes for this bill, but I can't not say this. So thanks very much.
Well, to the gentleman, I think this committee gives the gentleman plenty of opportunity to be heard. I think this is a committee that is known for its deliberation, and I would further note that it's not the prosecution's interest, it's the victim's interest as exercised through the prosecution in the state. And but what was in question in 555, outside of the confines of 556, was the wisdom of jury trials versus bench trials when there's not consensus about the same. And I think that's I would maybe advise the gentleman to reframe how he thinks about that. Chair recognizes.
Thank you, Mr. Chair. And to respond to my friend who I respect deeply, Representative McLaurin, back when I was running for office, and I guess it was probably after I got elected, my old trial partner in the Cobb DA's office, Marty First, who he was in the DeKalb Solicitor's office, in the Gwinnett DA's office, and he's been in the Cobb DA's office for about 15 years now. And, a lot of the case law that's out there on just about every kind of criminal issue you can imagine, he's been involved with. And Marty sat me down and he said, Bert, when you get down there, here's what I want you to do. I want you to change the law because it's crazy. It's totally inconsistent how some of these lesser charges that are non-7 deadly, why it is that we have to take a forgery is required by law to go before a grand jury, or a possession of a firearm during the commission of a felony is required to go before a grand jury. If you look at the list of crimes that are required to go before a grand jury, there are actually a lot of outliers. There are a lot of crimes that are much less serious than, frankly, many of the crimes that a district attorney is allowed to accuse today. It's a very strange list, and if I had known we were going to get this deep into this, I would have printed it to bring it to just kind of demonstrate how random that list is. And so Marty told me, he said, Bert, I want you to change the law. I want it to where we don't have to indict some of these lesser offenses like forgery. And then I talked to my friend Kevin Levitas. Kevin Levitas was a member of this committee for a long time when it was the Island of Misfit Toys. Is that right?
Correct.
And Kevin Levitas was a member of this body, and he stopped serving before I came here. And at one point, he had told me that he had actually tried to bring that. He during his time here had tried to pass a law, presented a bill that did the same thing, that required that a district attorney didn't have to take all of these cases that they have to take to a grand jury, that they could accuse some of the lesser ones. So I actually came here in 2014 when I was going to file a bill and do this because two of my good friends, we need to get this done. And then I got here and was told that previous efforts to do that had typically failed because, frankly, a lot of, especially in rural Georgia, DAs really enjoy going before the grand jury and having that interaction, and that because of that, there wasn't really an appetite to take this issue up. So some historical context, and really through the lens of a non-COVID time, there has been an effort, a conversation, and a willingness to look at this for some time. And I say that as somebody who at one point did look at this, and then I got busy with other things and let it go. But there's actually, been an effort that's underlied this for a long time, and I think that that I agree with Chairman Setzler this issue can be looked at. I understand we're dealing with both of these matters today in the context of the COVID court crisis, and that is a worthy discussion. But really, this issue is very different than the jury trial matter, and it really demands to be looked at, I think, in a little bit on the code red scale. This isn't as high of a code red matter as a jury trial thing is, and especially seeing that it requires that the 7 deadlies be drawn out of this. And again, there are some very serious crimes that are not 7 deadly offenses, but I think that this is a very different matter. So,
Thanks, Vice Chairman Reeves. Any further discussion on the underlying bill? HB 556. Hearing none, what's the pleasure of the committee? I think we have a motion do pass. Do we have a second on the gentleman's motion? And we have the bipartisan. That's right. Thank you. I was trying to find our way back procedurally where we stand. So we have a motion do pass and a second on HB 556 LC 412944. All those in favor of sending it forward with a do pass recommendation, signify by raising your right hand, please. Either hand. Thank you. And all opposed? Congratulations. Move on to full committee. Thank you. Appreciate your time. This has been an hour and a half discussion, but I think it's an important underlying questions we're looking at here, and I appreciate the engagement of the committee. That's not a trite remark by any means. We do have 3 more bills. There are 2 bills that I want to give particular time to. The lady from Fulton, HB 131 and 133, but because I want to give it some time, I think there's another bill that might be able to be moved on a little more quickly. So in interest of preserving some time for you, I want to recognize Representative Carpenter for 562. If you can't get this bill through in 10 minutes or less, you are booted out. We're going to lay it on the table. Hold on one second. Chair recognizes the gentleman from Dalton who's observing the charisma and spirit of this committee.
Yes, it's such a pleasure to be here, guys. In and out is my key here. House Bill 562, simple bill. It would just add DFACS caseworker or case managers to the list of individuals that we currently allow while they're performing their duties. We give them a little bit more judgment in issuing a warrant against them. So instead of allowing magistrate judges to do it, it would just allow probate judges, judges of state courts, and superior court judges to issue these warrants while they're performing their duties. We had a couple of issues around the state, I guess last year when I dropped this bill, where actually DFACS workers were performing their duty. There was a policeman there, and then somebody in the house actually went to the magistrate court, issued a warrant against them, and they had to go defend themselves. And so this is just saying we want a little bit more thoroughness on the issuing of warrants for DFACS workers. It protects our DFACS workers.
Okay. HB 562. What questions do we have from members of the committee? Chair recognizes Representative McLaurin.
Thanks, Mr. Chair. Representative, what was the number of this bill last time? Do you remember? 555?
That a baby, 555. That's a man. That's a man that knows his history.
That's right.
555's not had a great batting average today. Commissioner, thank you.
Let's separate those.
That's right.
Okay.
Yeah.
That's the only question I've got.
That's right. It passed. It just got held up in the Senate because of COVID. I assume because of COVID.
Okay. I've got Director Rollins, and is director the proper title? Commissioner, director? Director. Thank you, sir.
3.
Thank you.
Good bill, protects our workers from being swatted. It actually was next up on the Senate calendar to be voted on last time and just failed at the last minute just because the time ran out. Very much appreciate your bringing this bill again. Glad it's not 555 this time.
Yeah, if you've ever been in the position to be in the last out of the 9th inning and lose your bill on sine die when the clock runs out, it's not a good feeling. And I know that this is an important department bill, so I appreciate your interest. Any further questions for the author? Hearing none, what's the pleasure of the committee on 562?
Motion to pass.
Motion to pass in a second. Before us, as we have HB 562 LC version 392924. I've got a motion and a second. Any further discussion? Hearing none, all those in favor of sending it forward to the full committee with a do pass recommendation signify by raising either hand. All opposed? Thank you.
Thank you, guys. I
your time.
appreciate
Yes,
you.
sir. And Director Rollins, I apologize for making you sit through an hour and a half of, perhaps we could have managed that order better.
Thank you, guys. Appreciate
Yes, sir. So with that, Representative Maynard, welcome.
Thank you. I have more of these that I'll pass out afterwards.
Okay.
But for the sake of time.
And Representative Maynard, one of the reasons we didn't take your bills up first is I did want you to sit in the committee and kind of get a feel for this. This is a working environment. There's a lot of questions and hard questions. Doesn't mean the bill's not going to ultimately pass. We just need to get through these things and work out the details.
Yes,
We have
sir.
to live in that world. So welcome. Could you introduce yourself and your bill and kind of where this came from? And we will take up, in fact, let me ask you, would you propose to present 131 or 133 first, if you had the choice?
Let's do 133 first,
Okay.
since we just spoke so much about judges.
And if you could, I mean, if you're welcome to leave your mask on. If you'd like to remove it, you can for purposes of clarity. It's certainly within the rules of the committee.
Okay.
And you have the floor.
Okay, thank you, Chairman. My name is Representative Misha Maynard from District 56. House Bill 133 is an enforcement of Marcy's Law. So right now, it is required for victims to be notified. And right now, there's a loophole in that. It's just assumed that victims are notified. Why this is important? I'm a victim of stalking. I've been in the court system for 2 years now, dealing with a case of stalking in Fulton County. And I have an actual recording that I'd like to share with you guys. This recording, there was a person within the Fulton County DA's office that submitted a tip to Fox 5 News about my case. And the tip led to the recording of the phone calls, the free phone calls that inmates are doing in the court system. And on these tapes, the criminal defense attorney and the defendant are actually talking about, one, trying to get the judge recused off of the case, and two, trying to make sure that I don't participate in the case. It really got so bad where I had to send letters to the FBI Office of Violence Against Women because my rights were being violated. Okay. I'd like to also just interject that I have a master's degree in physical therapy. I'm getting my doctorate in business administration. I do not have a legal background, but in order to protect myself, I had to really read through the codes in order to just defend myself and say, hey, these are my rights. And that's where both of these bills came from. Okay. So for House Bill 133.
So before you play that for us, could you walk us through, I'll let you play a recording for us. How long is the recording?
It's very quick.
Okay. Just hold up the
and
mic.
my phone is going to die, so.
If the committee needs to furnish an iPhone power cable, we can probably find one.
And sorry, let me find it. Okay, and so let me just preface this. The criminal defense attorney is also the Fulton County commissioner. And so you're going to be hearing the Fulton County commissioner talking to the person that's stalking me while he's in jail.
Okay, so once again, let me get you the power cord, if that's okay. And then
There should be a plug here somewhere.
Thank you.
So Ms. Maynard, what we're hearing is the voice of a defense attorney and the voice of somebody that's incarcerated who had been stalking you.
Oh, small one, thank you.
Yes, that's correct.
Okay. So if the committee can, I don't know how loud this is going to be. If the committee can be on standby, I'll turn the volume up here.
It's 30 seconds, so it's not long. And because of all of this, I had to submit an ethics complaint to Fulton County.
And again, let's try to stay with the issues. Sorry. Let's try to stick with the issues of law. I don't want to get into trying to prejudice one person or another based on their role, but I just want to make sure we understand. There's a defense attorney, and there's a person that was incarcerated under what charges?
Aggravated stalking.
Aggravated stalking, okay.
After violating the order several times.
Arrington faces ethics bar complaint for conflict of interest. I mean, they're privileged.
That's why you said you won't even represent her, so where's the conflict of interest?
Right, well, she's saying because I'm a commissioner for Fulton County, I'm going to influence Paul Howard, and you know, I went straight to Paul Howard, and yeah, I sure did.
So, and I'm sorry, that was the stalker's wife that was on that particular conversation, not my stalker.
Okay, so you've got the wife of a person that was stalking you, and
Correct.
you have their defense attorney who's, you know, a politically engaged defense attorney in Fulton County, and what's your purpose for sharing that with us?
So the purpose for sharing that is they repeatedly were trying to not get me to be able to testify in court. And he was using this particular case, is this on? His particular case, he was using his influence, as this is an example, with Paul Howard, without the judge even knowing this is going on, right? For me not to be in court.
And again, my goal would be, if we could, let's refer to people by their titles, not their names. I'd rather manage this as a matter of law,
Okay.
not a matter of personalities. I don't want to get into, some names have been mentioned, and for those that are watching, it's not my goal to highlight any individual. That can divert things. That can create a dynamic that makes this feel less than objective on the facts.
I understand.
So those I wanted to give the lady some discretion there, but I do want to draw this back in. So that being the case, help us understand how 133 works exactly. Could you walk us through the bill?
So for 133, if you look at page 10, it says the judge of a court conducting a judicial proceeding in which a notification to the victim is reported under this chapter. And then if you skip to 14.
Okay, no, the lady was suspended. So I'm looking at HB 133. Look in the upper right. Is it LC 412685?
Yes.
Okay. So you're talking about line 10 on the
Yes.
judge of a court conducting? Okay. So your purpose in this bill, before we walk through this in detail, what specifically is the objective? Is this, I read it on its face to say one thing. Tell me exactly what your end state is in the bill.
So the goal for this bill is, right now, it's required for victims to be notified. But right now, it's assumed that victims are notified, because there's nowhere in the law except here where it says there's clarity that the victim was notified. So there can be.
And the judge provides verification of that through the process.
The prosecuting attorney will get that clarification to the judge. So in this bill, the judge is required to actually ask.
Okay. Any questions for the author from members of the committee? Chair recognizes Vice Chairman Reeves for a question.
Is there not something in the crime victim Bill of Rights that already requires that? I just know from being in court a lot, I used to hearing judges ask the state that question, and pursuant to the Crime Victims Bill of Rights, has the obligations of the victim notice been made? And I that's just something that I'm used to hearing in court. And so I'm looking in 1717 right now to try to read the other code sections for context. But isn't there something that already requires that? And I recall, I know that you weren't here. Marcy's Law was probably a 3 or 4 year effort that went through this body for many terms before it was finally passed, and I recall it very clearly. And I'm just trying to make sure, I'm looking at what this is saying, and I'm wondering if this is duplicated somewhere else in code, and if a judge, I'm confused at, as Chairman Setzler said earlier, it's clear as mud right now. I'm confused. Understand that you have been the victim of stalking, and that there was a phone call that you played for, said I'm not sure what that's for. Were you not notified by the court of something?
Several times I was not notified.
And then what stages in the at what stages in the level of that case were you not notified?
Throughout.
And
to the point where I had to contact the FBI office.
So who's was it? Are you suggesting that it was the position that it's your position that the district attorney or the solicitor, whoever it is that's prosecuting the case, would be the one that would be required to give you notice, right?
Correct.
But that and is the purpose of this to say that there was a judicial proceeding that took place, and in that proceeding, the presiding judge did not inquire as to whether or not the Crime Victim Bill of Rights were met?
Correct.
And so that what this bill does, at least what your intention for it to do, is to require that they make that inquiry on the record?
Yes.
Okay, and I think, I don't know if anybody from Judicial Council is prepared to testify to this, but I just want to, I know I've heard this done in court over and over and over again, and I don't know where that comes from, if it comes from law, and I would love to hear some thoughts from Judicial Council or Council Superior Court judges on that. I don't know if anybody's here that can help fill in that gap or not.
So what I'm hearing you say, Vice Chairman Reeves, is that you believe this is an important thing to happen, and you see it happening frequently. You don't know if it's in the SOPs of the court or if it needs to be required in statute. That's the question you have.
Yeah, and I think that what I would want to know is to hear if there's already a requirement elsewhere, because I think that there might be, but I'm not 100% sure. And if it's already required in law, then perhaps, if we've got a situation where if there may be judges that are ignoring it or not asking that question, then addressing that might be. But again, before I think we even get to that, I think I need to understand whether or not this is something that's already, that a requirement is or isn't part of law as of today.
Do you know if this is in a uniform court rule or?
I do. So Legislative Council, we went through this extensively, and what they ended up coming back to me is it is said within Marcy's Law, but since there's no statute that lays it out where it has to be a blanket statement made on record, there's the possibility that victims are not being notified. And I would like to say that since my case has been public, I've had multiple people contacting me, telling me their stories. There was even, I did a press conference on this at the state capitol. Dr. Melanie Bliss with the Thrive Center, she also spoke, and it's a recording of this, about how victims are not being notified. It's a problem within not just stalking, but also victims of domestic violence are not being notified of the court cases.
Okay. Chair recognizes Representative Byrd for a question.
Thank you. Could you just tell me what is it that you're not being notified of, so I have a full understanding, please?
The court date. A hearing.
Okay.
And so I'll give you a couple examples of when I was not notified. At the very beginning, at a bond hearing, I wasn't notified. During my particular case, because this particular victim or this particular defendant requested multiple judges trying to get the hearing that he wanted, that meant there were multiple different hearings, and so I was not being notified. But in particular, this is the really most important one. After I contacted the FBI told the DA's office, you know what, because at this point he was out on his second bond for violating the order. They suggested that they do an emergency bond revocation hearing. And at that emergency bond revocation hearing, they had the prosecuting attorney on Zoom. So I was in the courtroom. I knew about the court case, right? And I wanted to present to the judge, raised my hand in the courtroom. Someone from the bench came and told me I couldn't do that. So I wasn't able to say, hey, I'm trying to speak. So I had to end up having an investigator that was escorting me to and from my car to the courtroom to go outside of the courtroom, send a note to the prosecuting attorney who knows I want to present my case, and say, hey, this is her right to talk about her case. And so at that point on the Zoom, the prosecuting attorney said, Your Honor, the victim is in the courtroom. So case had been going and she had no idea I was even in the courtroom.
Any further questions for Representative Byrd? Okay. Chair recognizes Vice Chairman Reeves.
So with this, is your intention that this analysis, that a judge would be required to have something on the record in every, whether it be a bond hearing, a probable cause hearing, an arraignment, a motions calendar, a calendar call, all of the different events that bring an accused to court? Would this require that the judge in all of those matters make that inquiry?
So right now, that is the law, according to Marcy's law, that the victim is supposed to be notified in all hearings. It doesn't specify what kind of hearing.
And so, and I can't remember from when we did Marcy's law. I can't remember the details of that, and I take you at your word for that. But your intention here is that the inquiry be made by the judge on the record at every court appearance that an accused is to appear at, right?
Absolutely. Absolutely, especially when it comes to the cases related to the Crime Victims Bill of Rights.
Okay, and I think what I needed, so what you, and I'm not trying to trick you, you just said two different things though, like, I don't know which, it's been a while since I've read the Crime Victims Bill of Rights, so I don't have it memorized, but I can't remember, as far as which hearings are relevant to the Crime Victims Bill of Rights and which are not. You know, one of the things that I think that has to be looked at with this is there are a lot of court appearances that an accused has that their appearance is waived at. Like, for example, usually if they have an attorney, the attorney waives arraignment. If they, most courtrooms have a motions calendar each month, and they'll appear on that motions calendar potentially for several months. And if they don't have a motion to file, then they don't appear. And so there are all kinds of things that happen kind of mechanically underneath stuff that dictate whether or not somebody appears. And what I'm trying to figure out is this kind of oral finding, or this oral discussion to go on the record about whether or not the victim received notice. I'm trying to figure out what it would apply to, and I think you said that it would be pursuant to the Crime Victims Bill of Rights, but I don't know offhand what that means as far as what.
It's pretty, it's 1717, and that's a whole, that whole chapter. There's a whole lot of It's buried in different code sections. I was reading some of these, but I don't think
Does
I've
it-
got the totality.
Is there anywhere where it's listed the?
And if I can, on line 17,
Any judicial proceeding.
it may be where the victim does not want to appear. And so on line 17, it says, you know, the reasons for such failure and where the court deems necessary for the fulfillment of the purposes of this chapter. So this just is trying to make sure that the victims are being notified, because that is what the current law is.
And I think that the number 3, I'm looking at 1717.5 right now, and it applies in number 1, the accused arrest, number 2, release from custody, and number 3, any judicial proceeding at which the release of the accused will be considered. And I think the interesting thing about that is that sometimes bond is worked out at an arraignment, sometimes bond is worked out at a motions calendar, sometimes there's a motion for bond filed, sometimes it's not. That's kind of a moving target, and so I think that and I'm not saying that I have an opinion one way or the other, but I think that what this potentially requires is that oral finding be made at what would be every hearing or every possible court posture if the person's in custody. If they're not in custody, then it seems like this doesn't apply. But if they're in custody and stand to potentially be released, and that would probably be for every. And I would really want to hear from judicial counsel with just kind of their thoughts on this. I don't know if they can testify on it or not. I don't know if anybody's outside that can do that.
We're going to reinvigorate. Could you go outside and see if there's anybody who wants to sign up to speak on 133 or 131? I've got a couple folks that are. In fact, before you go, let me take a look at this. Right now, I've got only one entity signing up on 131. So could you ask if anyone in the hall within the sound of my voice can hear, if you want to be heard on 133, now would be the time to identify yourself to our staff assistant so you can be heard on it. Any further questions for the author while we're sort of waiting for others who want to address the committee?
I do have Dr. Bliss, where I can call her and she can speak through speakerphone to this in reference of her support, and also the National Women's Law Center and the 9 to 5 organization here in Georgia. They have both provided letters of support for both bills.
Okay.
And if I could just add any statement, this doesn't change Marcy's law wording in any way.
Okay. I think there's two questions. There's the underlying question, is it good policy to mandate that the judge ask these questions on the record? And and the second question is, does the mechanism you've provided in this 21-line bill, is this the mechanism to accomplish that end? I think those are two questions. So there's the question of, is this needed? Is this provided for already? And if that's the case, we still have to answer the question. If the answer is yes, then the question is this the way to do it, word for word? Is this the appropriate way to address that end? Chair recognizes Representative Smith for a question.
Thank you, Mr.
Are you number 4?
Yes, I am. Thank you. Is it working? Thank you, Representative Maynor, for bringing this bill. I understand this has affected you personally, and I'm sorry that you had to undergo this. I'm even more regretful that it sounds like our system of justice failed you at certain points potentially, so I do apologize for that. My concern that I have with it is, having done a little bit of practice myself, to me this seems like this is potentially having the judge in a way do the prosecutor's job for him. The judge is inquiring as to whether the victim has been notified. Now, I have seen when I have a victim involved in a case where the judge does inquire. My judges inquire where I live and where I represent, so I give credit to them. But, from a disposition of a case standpoint, do we get in a situation where if you don't have your witness there, more times than not, depending on the situation, I'm going to move to dismiss the case.
Exactly.
And so I'm the burden is on the prosecution. And whether this is burden shifting, I mean, to me, it's an issue there. You know, the judges do inquire about this, so I don't think requiring them to do this. I think we've got to have a little bit of faith in our judges. Now, I will submit to you this. If there are judges not doing this, if there are prosecutors not doing this, what I would submit to you is y'all get y'all citizens together and y'all vote these individuals out of office. We've had a lot of talk about elections, and I think that we still have the power of the ballot as being one of the most powerful. And that goes for our judges and our prosecutors. I mean, we see this time and time again. We think that we can legislate somehow better than what the voters can interpret what's going on and hold our elected officials accountable, if that makes sense. I appreciate what you're trying to do here. I'm a little concerned about it from that standpoint. I mean, what position is this putting our judge in making this inquiry?
You got the floor. You're the author.
If I could respond, thank you. So I think we also have to consider different municipalities and systems are going to have different burdens.
Yep.
So in a rural area, it might not be as many cases coming before the judge, and the judge is able to always ask, and the prosecuting attorney may not be burdened, right?
Yep.
In Fulton County, each single prosecuting attorney has 60 cases or so. So I'm just a number, or anybody is just a number, and they're trying to get through these cases.
Sure.
And so at times, even though it might be every judge's intention, right, to make sure that they ask, but when you have so many, there is room for error sometimes. And there was a discussion earlier about the goodwill of judges. I support the goodwill of judges. They went to school and they got the experience to make decisions based on the theory of law, right? So this is not meant to question a judge's judgment or how they do it, but it does allow them to actually have the facts presented to them in case the prosecuting attorney does not present it to them.
Sure.
Because to his point, if you're not there as a victim, then how important is the case to you? But if you don't even know that you're supposed to be there, that makes a judge's can make a judge biased.
Sure. Well, I tell you, let me tell you where I think we are now. And this is why I highlighted this sort of two steps. First step is this a problem that needs to be addressed? Second step is, do the words on this page address that adequately? So I think we're going to need some more work to get us confident with the words on a page as being the laser-focused approach to addressing this. I am persuaded, as a member of the committee, that we have an issue to make sure that victims are informed. When you look at the Crime Victims Bill of Rights, it talks about shall notify where practical. Any of those qualifiers can be gaps through which error and overwhelmed. One of my best buddies in the Army left the Army as a JAG officer, went to Miami-Dade and picked up a caseload. It was just a crushing caseload the day he walked in the door. There's a lot on them, but victims have rights. So I think we're in a place where we want to make sure that these are effectuated. I don't know that where members of the committee are in terms of being prepared to act on this language today. I will tell you, as a subcommittee chairman, I commit myself to not letting bills fail for failure of consideration of the subcommittee. So if there's a way we can work through this and get you across the finish line in time, I'm committed to that, unless a member of the subcommittee has a proposal that could perhaps solve it here around the table today. With that said, I'll recognize Vice Chairman Reeves.
Thank you, Mr. Chair. I think that this is this is a good idea, and we need to dig into this. I think that some of the things that we've got to, some of the approaches we have to take to issues like this are kind of some of the practical implementations of, for example, the very end of the bill, if the prosecutor has not been able to make contact, then the judge is to direct the prosecuting attorney to remedy the failure of notification. Speaking from experience in this, you would not believe how many people's phone numbers change and their contact information changes through the life of a case. And I've had cases that were teed up and ready to go to trial, and then all of a sudden victims, their number changed. I couldn't get in touch with them. And so there's some practical things. And I also believe that there are some circumstances in Georgia where prosecutors are not in the courtroom for an arraignment. And so I think that you have a good idea here, because let's be honest, figuring out how to make our laws and our crime victims bill right better when it comes to the notification of victims is something that should be a priority for all of us. And it and I'm very familiar with the often repetitive fact pattern of cases where a victim some victims just tell the prosecutor, do whatever you want, it doesn't matter to me. Some want to be involved and want to know, and it's very important to them. And when those that are engaged at that level get cut out of the process, that's a deep wound, and it frankly shatters their confidence in the criminal justice system. And I think that's something that you might be able to relate to, which is why you've brought us this bill. I think this is a good idea and something we should look at, but I think there's some things that we're going to have to dig a little deeper on. And I agree with Setzler. I'm certainly willing to help to try to get us to a place with this in the next few days. So thank you for bringing this, and let's keep working on it.
Thank you.
As a matter of perspective for you, a significant legislative accomplishment of mine, which took me 4 years to work on, ended up passing in Senator Jones's bill a couple years back in Senate Bill number 9. So there's time. There'll be a lot of propositions that come to this committee. This could perhaps be tacked on. I do think we need to. I don't have a level of confidence that this language is the exact language in the exact place that even accomplishes what you're trying to accomplish without wiggle room, that the same conditions that exist today wouldn't continue to exist. So I'll pledge to you that we'll work with you on this. We might be able to get it by crossover day. But let's do it. I think there's some folks we need to consult offline on this language specifically.
I'm open to that.
Super. So 131, another important proposition. Representative Maynard, could you tee up this for us? And I know in some ways it's a companion bill for you.
It is.
Speak to 131 and exactly how it works and what the changes are that are substantive from current law.
So right now, so how the reason 131 came about is if you call the police and you need help right now for a stalking case, the police officer is making a decision if he believes this is stalking or not stalking versus completing a report that's already required by state law. And who should really be deciding if this is stalking or not stalking is the investigator. And then the investigator then presents that to the district attorney's office. So if you, in particular, so there are not a lot of changes, but I do want to go to line 42. And it says each violation of the code section shall constitute a separate offense and not merge with any other offenses. So right now, if you are being stalked by one person, what's happening right now, they will tackle on every single offense to that one charge. The problem with that, though, is aggravated stalking. The charges are not cumulative. It's every incidence of you violating the statute, which means if you have a restraining order against someone and they violate that restraining order repetitively according to the courts, then that then becomes aggravated stalking. But the way the law is written right now, if you violate the order 5 times, then it all goes under just that one. When indeed separate instances. So when you go in front of a judge, you need to be able to show the judge multiple charges instead of just one charge.
Okay. I've got some questions to that point, but I'll defer to members of the committee first. Also, that's raised on line 42. What other, what about the addition, this question of eliminating on line 28 other than the residence of the defendant, and then indirectly through third parties? Could you explain those changes to us as well?
Yes. So, which line are you referencing?
Line 28. Apparently, there's a provision that if you're in and around the residence of the
right,
the defendant, that would be an exemption, that they live there, they're just going to their houses, and you're eliminating that, I guess. And what's the reason for that?
And this is actually brought to me by several of the organizations where I have these packets from. So right now, if someone is charged with stalking by a judge, they have deemed that this is stalking, there are measures in place where the woman or the man is not able to get away from their stalker if they're in that same household. And so this eliminates that problem.
So, and by the way, could you get Ms. Travis in here? Let her come in. I'll ask her a question in a moment. So what you're saying is this is limited to a household, or this is, let's say someone lived in a garden apartment on up the second floor, 4 doors. If this door were the stalker and this door was the victim, as it were, I read this, and members of the committee may read it differently, that if you're going from your car up the stairs to your house and you're seen there, that can't be called stalking, because as a matter of practicality, you live 10 feet, your front door is 10 feet away from the door of the person that you're supposedly stalking. I think that's what this does. Let me just ask parenthetically to members of the committee, line 28 is what we're talking about. Is that the committee's common understanding, and if so, what implications do members of the committee see with respect to striking the stricken language on line 28? Representative McLaurin's willing to dive in with an answer.
I'm willing to float around the answer, Mr. Chair. We had a discussion about this previously, correct? With regard to there was another bill where we talked about the implications of a defendant being liable for being at their own residence and otherwise violating the code section. Is that right? I recall a discussion about this. I think it was on Representative Gaines's bill.
Okay.
I mean, the implication is that that if the victim is at the defendant's residence, that stalking can't occur, because I guess stalking is, the current understanding of it is that it's sort of a forward. There's a directionality to it, right? That you have to pursue somebody, and so if the victim is at the defendant's residence, then that element of pursuit, it seems like, maybe is absent, or that somehow maybe there's an intuition, and this is again orbiting the answer, maybe that it's almost like coming to the nuisance, that if you're at the alleged stalker's residence, then you are somehow availing yourself of the presence of the stalker in a way that, I think that's the argument for having that language in there. That being said, I could imagine off the cuff that there are probably circumstances where you could find yourself unwittingly at the residence of the defendant, or if residence of the defendant is broadly defined, you might have a legitimate reason if maybe you're sharing custody, and I don't know exactly all the contours of family law on this point, but I can imagine that a hard bar that says you can never be at the residence of the defendant would probably exclude some cases in which a person, because of coercion or pressure or some sort of reason to be at the defendant's residence, could still be a victim to the type of conduct that stalking attempts to criminalize.
Sure. I can imagine a stalker that lives a house away and sits on their back porch with binoculars and watches you. And it's a very prominently. I mean, I can imagine that would create this oppressive atmosphere. Does the person, by virtue of living next to you, do they have impunity from the stalking? It's a fair question, right? So, I think to Representative McLaurin's point, which I would follow, that the presence of you at your house shouldn't, by virtue, make you the stalker. But is there a set of circumstances that could give rise to the stalking behavior still being performed at your house, on your property, or whatever, in a way that this shouldn't be just a blanket exemption from? That's to me, it's maybe a textured issue, multi-tiered issue. I just wanted to know, in striking this language, is there a specific fact pattern that you experienced personally, or was brought to you that you want to address specifically?
It was brought to me.
Okay.
They wanted, since I was bringing this bill for other reasons, this was something that several organizations feel like should be included when they're trying to protect the rights of victims. So I apologize for not having all the background to it.
Let me ask this, Ms. Travis, are you able to address that question? I mean, what you see the implications being of line 28, the stricken language? What's your mic number there?
It's number
13. Ms. Travis.
I'll hearken to the words of this committee that's used frequently is the castle doctrine, the castle being your home. It is a very big step to remove your own home as being a place where you're protected. This is the stalking statute. If somebody was cohabitating and had a difficulty with a person that they lived with, they could get a TPO.
Yeah.
This is a very big change to the code, and would ask to seriously consider whether this committee would be willing to go that far.
And I think there are questions too of invasions of privacy. I mean, if you're using certain means to, I know certainly look into someone's home, that's not necessarily what you're thinking about. I know there's a, what is it? I should know that code section. So it does seem to be a big policy step for line 28. I just wanted to understand if there's a compelling reason that you're trying to accomplish this, and if so, what are the contours of that? What should be in, what should be out? What are we trying? And is there a narrower way? This is a pretty big step, I would think, to strike that language. That was my concern.
So I would be willing to not strike it.
Okay.
For the record.
Okay. Down below on line 38 through 39, maybe this will generate some discussion. The language you have on 39 through 41 is copied from above. It's the elements of the existing stalking statute.
Correct.
The indirectly through third parties. Walk me through your thinking behind that.
So right now, well, actually, this is currently what the law is already. So if someone is stalking you, they're not supposed to contact you directly, not supposed to contact you online. They're not supposed to go to another person and have the other person come and contact you. So there's no change there. This is currently what is in the current code.
You're talking about lines...
The 39 through 41.
Right. Well, no, I think 36 through 38 is the indirectly through third parties, though. What's the meaning of it? What are you trying to capture within this addition of indirectly through third parties that you can be? I mean, in essence, if I were trying to stalk somebody, if I had some agent do the stalking for me, this third party, call it Representative Smith, who I have, he's my agent, my stalker agent, as it were, that I'm still guilty of stalking because I have him doing stalking. Is that what you're trying to accomplish?
So the current law says indirectly and through a third party, but I can give you an example.
Okay.
So in my own personal example, my stalker contacted another person unbeknownst to me and asked me as a state representative to help them with a nonprofit organization.
Okay.
After we began dialogue about the nonprofit organization, then the person said, "Oh, and by the way, I work with such and such." So it's like, okay, I clearly cannot work with you. I have a restraining order against this person. So I was about to be brought into a situation where I was going to be entering into a relationship, a business relationship, albeit with my stalker, which would not have looked good for my case. The judge would say, "Why are you involved in this case?" Right?
So by virtue of arranging this third party to enter an arrangement with you, maybe set up a meeting at a place of business or whatever that you would come to, where you would walk into the presence of the stalker, you're
Correct.
looking to create that circumstance as a crime.
If it's in relation to this, yes. If someone has a restraining order, they should not be fooled per se into entering into something that completely violates the restraining order, because the judge would say, "Why did you go there?"
Yeah. Okay.
There's another example that I actually looked up where a woman, this was a case, and I can find it for you, but there's a case where a woman divorced her husband. He continued to stalk her after the divorce. There was a death in the family, and the woman, a family member of her ex-husband, said, "Hey, do you want to come to this funeral?" So the woman comes to the funeral, or she meets the man, in a state, and the man sets her up in a hotel. The woman and her children are in the hotel, and unbeknownst to her, this family member of the ex-husband has given the keys to of the ex-husband, and now her stalker. So now he is in the hotel, her stalker with her. I don't know if that made sense the way I said it. So that is another example of a stalker using someone else to bring someone into a situation for the purpose of stalking them. And I'm happy to find that case for you.
Okay. What questions do members committee have for the author at this point? Any questions about the discussion we've had thus far? Chair recognizes Representative Reeves.
I don't think we've talked about it, but I know the last part of the bill requires it requires an audit by the GBI. Have you talked to GBI about this?
Can we hold off on that piece? I'm trying to walk through the bill piece by piece if we could. If you could hold off on that one. Sure. Does anyone have a question about, in essence, lines 36 through 41 of the bill, this issue of this third-party stalking charge, in essence? Representative Smith.
Thank you, Mr. Chairman. Just as that is written indirectly through third parties, that's a little. I can understand why it would be written this way, but I think maybe trying to tighten that up a little bit. I've got a lot of concern with that, and I need to parse through it some more. But as written, I'm afraid of what that might, encompass. It might encompass, a situation where the third party wasn't aware, or were they aware? I mean, we're getting into some stuff here that I think is going to be tough to prove as is.
And I raised the question. I appreciate your remarks, Representative Smith. We have to understand that this is a criminal statute that we enforce with jails and the police powers, and I just want to make sure that this is something that we are advised to add to our criminal code. I'm wrestling with clarity on how this is is there some other theory of law where it's a criminal conspiracy or some is there another way this could get prosecuted, with particularly with the if it were an aggravated stalking circumstance. Let me ask this question to Ms. Travis. Ms. Travis, what's the criminal penalty for aggravated stalking? Do you know offhand?
I think it's can be 10 years. I think it can be even higher than that.
Okay.
It's a minimum of 1 year up to 10 years.
So aggravated stalking is 1 to 10, and then stalking itself is it high a misdemeanor or?
It is a misdemeanor.
It's a misdemeanor.
So what I'm thinking here, I'm just thinking out loud here, guys, which can be dangerous. I mean, if a person through conspiracy or through some kind of scheme tries to effectuate what otherwise would be a felony, isn't that a conspiracy circumstance under our current law?
One of the things that's pretty clear to I mean, you're looking at me and I'm just talking. I've been trained. The party to a crime would cover the circumstance. Party to a crime would cover the circumstance that was described earlier. So if we're going to stalk Representative Reeves, I want to stalk Representative Reeves, and I engage you to help me accomplish that goal. And you know what you're doing. You and I talk about it. You know that he's going to be in his office at such and such a time, and whatever is going to go on for you to help me. You're party to a crime. That's already covered by current law.
If I were an unknowing participant, not understanding that he has an order against you, and I were just unknowing, but arranged that, but you had full knowledge of that, would you not still be? Is that still party of a crime? Or because it's not a crime I'm committing because I don't have knowledge of it. But if you were to orchestrate me to set up a meeting where I brought Reeves to you, that's I think what the underlying behavior she's trying to affect here.
Well, the expertise on prosecution, I'll leave to the other side.
Okay, fair enough. Chair recognizes the real chair. What's your number, Mr.
Seven. I share what Representative Smith was saying, in that it's kind of confusing how it's written. Maybe something that says that if you direct a third party to place under surveillance, then the rest of the statute. So it's one person acting to cause another third person to place under surveillance or contact another person. And then if you read the rest of it, it doesn't. I don't know that it matters if you're unknowingly or not, because it's for the purpose of harassing and intimidating the other. I just wanted to throw that in there.
Thank you, Mr. Chairman. To the author.
So I have my restraining order, and I want to read paragraph 3 of the restraining order. And it says, respondent is not to have any contact of any type, direct, indirect, or through another person with the petitioner of his or her immediate family, including but not limited to telephone, fax, email, or any other type of communication. So I got the word indirect from the restraining order. So it might not be currently in the statute, but it's in the restraining orders, at least for the Superior Court of Fulton County.
So is the aggravated stalking, this is a parenthetical question, if perhaps for anyone who would want to jump in and speak to this, if the court order says what your court order says and you violate that court order, does violation of court order and a stalking, the stalking fact pattern, those two things together make aggravated stalking?
Correct.
I believe that it does. So you've got a 1 to 10 felony behind that order right now that effectuates this third-party circumstance based on how the judge wrote the order, correct?
Correct.
So we could leave it to judges potentially to create this. I mean, there might be sort of some uniform language that judges might choose to use that would give you that protection via third parties, indirectly or indirectly, without putting it in statute. Because it sounds like today, because of the nature of that order, you already have access to this. Your would-be stalker is already subject to aggravated stalking if they violate that order. It seems like today, without us changing the statute, it would seem.
in Fulton County, but not all counties have that.
Have
So,
that,
but
yeah.
to your point,
Yeah.
it would be up to the judge to decide.
Okay.
And I'm not sure, according to code, if it's not in the code.
Okay. So you're thinking there may be some court SOPs that are best practices that you might want to codify, is what you're sort of thinking about in the theory of the bill, basically.
Yes, because again, it's not just me, right? This is victims all over the state of Georgia that are, counting on me to help them with the system, the loopholes that are in place.
Sure. Representative Smith.
Thank you, Mr. Chairman. I'll just say this, and I'll look to Miss Jill on this. As I understand, in my opinion, I mean, in certain venues and jurisdictions, they give these things out like chiclets as far as TPOs and the like. So I think maybe, and again, are we? There's a lot of discretion in application of the law given, and I wonder if we're just. I wonder if this is just trying to stop or put a square peg in a round hole. And I wonder that. I mean, I'm sympathetic. I really am. But I'm still worried about the hole that this could potentially open. I mean, of course, disclosure from my standpoint, I already think they're easy enough to get. I think that if you've got the evidence on your side, that you should be able to prosecute others. And it sounded like even in your in the order that you read for us here in the committee, it seemed like part of what you're trying to accomplish here in this bill was already done in that order, and I've seen that myself. That there are certain hypotheticals we can come up with, but I think in this situation, I'm really afraid about the hole that it opens up, written as is.
To the lady, I would tell you that let's do some more homework on this. I think what we're looking to do as a committee is sometimes things will just sort of converge towards an answer. I will pledge again to work with you on this. If there's some narrowing we need to do, if there is a circumstance where you've got some court SOP best practices that are put into orders that we feel like we need to codify, I think what you would want to bring in is you'd want to bring in before the committee a proposal that lays these out and says, I think this is worth codifying because I don't believe it's being used universally across the state. This is our first look at this. And I think the members give you a sense of kind of where their concerns may be, but again, I think this is an issue we think there's broad interest in. The last thing I would share with you, and I'll recognize Vice Chairman Reeves to speak to his question. My question was on the 42 through 43, the shall not merge language. I don't have an answer to this necessarily, but I do know in line 29, as it applies across the article, there's a knowing and willful course of conduct. There's sort of you didn't show up one time and look at me funny or stare at me. There's this continuous course. So if that's the case, as it applies to stalking, not aggravated stalking where you already have this order, but stalking itself, if there's this sense of a course of conduct, is 3 a course of conduct? Is 4? Is 5? Maybe it takes 3 or 4 to demonstrate there's this course of conduct. Are we suggesting that that's 3 offenses, 4 offenses, 5 offenses? Or is it just in furtherance of this course of conduct which has to kind of crystallize and distill to be a stalking offense in the first place? That was my concern about the merging language.
Okay, and in regards to that line, I do think that's up to the judge and the evidence that's presented for the judge to ultimately decide, is it stalking?
I don't disagree, but when we say it shall constitute a separate offense,
I see what you're saying.
that's the issue. Is what are we? And there can be different disagreements on policy. One thing our subcommittee is charged with, though, is to be clear what we're doing. We're not putting out things that we're uncertain of. So that would just be a question I would ask you to answer before we sit back down again and go through this. Let's make sure we can answer that question.
Okay.
To that, I'm going to recognize last question, Vice Chairman Reeves.
Very briefly, the very last section of the bill requires some auditing and reporting on the behalf of the GBI. Did you talk with the GBI about this, and are they prepared to be able to take on such responsibilities without an appropriation? I know anytime we add anything to an agency here, the response is usually that's going to require a resource that I don't have. So tell me about that.
Thank you for that, Vice Chair Reeves. So the interesting thing is the GBI is already supposed to get these reports, but nowhere in the statute does it say what's in the report, who's going to do the report. So right now the GBI is not getting any reports because law enforcement is not doing it right now. So the law is currently, law enforcement agencies are supposed to send these forms to the GBI, but that has never been done because there's no form. And so this is trying to create the establishment of that.
Mm-hmm. Okay.
To the lady, I like Section 3 and 4. I think there's some value in it. I think full and complete description may be not completely defined, but I do think fleshing out the circumstances in these cases, not just this person's been accused and there's no detail there to flesh out. I think it serves all interests to have more information. So I like what you're doing in Section 3. I think Section 4 is maybe missing a page here, but I think the last page, it's Section 3. I will, if you can have GBI prepared, maybe I can maybe catch Miss Miles in the hall and talk to her about this, but I do think you're onto something with Section 3. It's very different than perhaps the other parts of your bill. But any last comments for the committee? We're not going to take action on this today, but I think it's a great first presentation. So
I appreciate that. And I really do appreciate you letting me present this to you guys. So one, everyone is aware that there are some issues that are in the justice system, but two, for Section 3 in particular, right now we don't have any data coming to this General Assembly that lets us know how much stalking is even out there for us to make other decisions. So that's why Section 3 was added.
And I'm concerned of accusations of stalking. I'm concerned the facts underlying TPOs. These are very serious when your name gets on the list. I think there ought to be. I do think there's a due process interest in that being defined more fully. I think everybody benefits from that. So I appreciate opening that discussion. So with no further questions, we're going to suspend consideration today for 130, 133. Let's talk. Glad to talk to you on the floor this week if there's some things we can work on. These members of the committee all practice law and have various perspectives. So I would ask you to consult with Representative Smith, Representative Reeves, Representative McLaurin, and others to help kind of guide this towards a converging outcome. So thank you.
Looking forward to it.
And with that, we stand adjourned. Reeves Subcommittee will convene at